On-call interpreters and translators provided language interpreting and translating for a range of clients. They had some 2,500 certified interpreters on their books who they could call on to complete work. The Commissioner for Taxation ruled that these interpreters were employees of the business, so On-Call was liable to make compulsory employer contributions to superannuation. On-Call challenged this decision, arguing the translators were independent contractors. The federal court therefore had to decide the true nature of the relationship. Justice Bromberg said the distinction was that when personal services are provided to another business, an independent contractor provides those services whilst working in their own business, whereas an employee provides personal services while working in the employer's business. How do you tell the difference? Justice Bromberg said that this was the test. Viewed as a practical matter, is the person performing the work of an entrepreneur who owns and operates a business, and in performing the work, is that person working in and for that person's business as a representative of that business and not of the business receiving the work? If the answer to that question is yes, in the performance of that particular work, the person is likely to be an independent contractor. If no, then the person is likely to be an employee. He set out dozens of indicia which a court could use to properly identify the relationship. He said, a genuine independent contractor providing personal services will typically be autonomous rather than subservient in its decision-making, financially self-reliant rather than economically dependent upon the business of another, and chasing profit, that is, a return on risk, rather than simply a payment for the time, skill and effort provided. In an employment relationship, there will typically be an entrepreneur, but that will be the employer. It will never be the employee. The employer will take the risk of profit or loss. The employee seeks the security of fixed and certain remuneration. Unlike the independent contractor, the employee has no business and typically will have no interest or desire in exposure to the risk of loss in return for the chance of profit. From this case, we get more important insight into the distinction between an employee and a contractor. The law does its best to identify the actual nature of the relationship and not merely the label which the parties have placed upon it.